Hey there, welcome to Help Solve the Case. I'm Christine Burke. If you don't know me, I'm a retired police detective and sergeant, current law enforcement expert witness, and we are here to evaluate all of the cases, all sides of it, and you can provide your opinion. We'll hear my opinion so that we can learn more about what is going on, how it's being challenged, and how it's going to be applied across court cases in the future. And today I am coming in hot on the Alex Murdaugh hearing. The end of it is still going on, but I was so particularly perturbed about the DNA portion. I had to get off. They took a break and I had to get off. And I know that you all want the information as soon as practical. Practicable is the word they use. Here we are, uncut and unvarnished. All right. There was some back and forth. There were a lot of motions. I didn't realize that they were going to have all the motions. I have my notes here, and I will tell you, I'm going to go in depth in certain areas of this. In particular, I'm going to go over the motion and talk about the judge's order and what I think can happen, why, and tell you truthfully whether I agree with it, because there's some stuff that went down today that I think is absolute BS. I don't agree with it. And do I think it was intentional? Absolutely not. Do I think it's because of ignorance? Yes, 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 yes. We'll talk about this. There was some mention in the beginning about obligations under Brady, under Giglio, and the state was, look, I'm well aware of my obligations. I don't think I've failed in any of my obligations. And the defense was talking about plea deals, bias, credibility issues with the police, secret agreements between a co-defendant, Curtis Eddie Smith. They talked about wanting to get information because there was a November 2021 conspiracy case about filing a police report. This concerns witnesses in the cases. And again, I apologize because I'm not up all on that. I was, oh my goodness, this is terrible. And we need to learn more about that. So I'm going to go in depth on that. They also talked about a June 2022 indictment. This was the background apparently on this Curtis Eddie Smith. And they were talking about, was there a plea deal because this Curtis Eddie Smith, the co-defendant, has current cases pending and they have not been concluded. And under disclosure rules, if the state is offering anything in anticipation of testimony, right, substantial assistance, what they call it, the defense says, look, we're entitled to know what is going on. And that apparently, allegedly, Mr. Smith is facing, again, I'm not familiar with this person or what these are. I just was making my notes. November 2021, there's a conspiracy for filing a police report in a June 2022 indictment for money laundering and meth. And talking about that these cases have been pending for 4 years and they have not been disposed of. So the defense is saying, why not? Are they cooperating? And is this person going to be a witness in this case? Because if this person is going to be a witness in the case, we need to know everything that's going on for Giglio and Brady for exculpatory information and the ability to impeach the witnesses. They also mentioned that there was police misconduct potentially that I have here. Judge Young dismissed a case, Michael Colucci, 2015. There was a June 2025 dismissal that the state withheld evidence on the eve of trial, something about SLED. I'm not exactly sure what that is, but of course, I'm going to go through that. We're going to take a look at that. And so the defense was saying, we want to know what is in the personnel file. And it was very interesting. We'll get to that in just a moment. They also talked about this person or a person being the lead in the financial crimes case who went to work for the Charleston County Sheriff's Office. And on June 8th, 2026, just not too long ago, was terminated, violating some rules and conduct unbecoming and harassment. Now, the defense said, look, we don't have subpoena power for this, Your Honor, so you're going to have to give us this information, and we believe that we're entitled to it. We should not have to have a hearing on it. Now, This is news to me because here in Maricopa County, where I live, we get everything. They're talking about the defense is saying we need to see what happened not only in these two recent court cases concerning the police officer, what did the police officer do or fail to do that resulted in the overturning of the case or the firing? Does that have bearing on impeachment or credibility in this case or what they've testified to previously or the prior investigation? Because remember, and we'll get to this, is it a new case or is it an old case? The state is relying on that work in this case. All right. But it could all be problematic. And I believe that the defense should get it. All right. Now, I was shocked that they can't get that information regularly. I get everything. I get the supervisory file, I get the training file, and I get the HR file regularly. And the prosecutor, I was actually standing out in the hall in the court with a defense attorney talking about how they didn't have the information. And I was, you should get that. And the prosecutor was sitting right next to him. And they were not on the same case, but the prosecutor was, yeah, you're entitled to that. Very, very interesting that not only, and I don't know if the defense is saying that they don't get to subpoena at all, which is a huge challenge to me in hearing the cases. I'm going to look more into that. But we here in Arizona, in Maricopa County, have, let's knock on wood, pretty good access to this material. And that's a huge part of the case. It's a huge part of what I do as a police expert to say either the police did good or the police did bad. I work on both sides of that equation. They also talked about Brady, which is exculpatory information. All right. So Giglio is impeachment. Brady is exculpatory information. And it's crazy. You may know about this if you follow the case. I could not scribble fast enough. They were talking about news of a recent murder in Allendale County that the Murdaugh murder weapons, all this alliteration here, folks, were connected to this recent case. And the judge even said her eyebrows went up. My eyebrows go up. And yes, I have a little twang because I was listening to the judge and I'm from the South, so you might hear it. They were talking about the defense was talking about the SLED lab, which is the South Carolina Law Enforcement Division, I believe. I don't know what the D's for. That in the Murdaugh case, they had just tested the shell casing, saying that it came from a 300 Blackout, and they tested the extraction mark matched other casings, I believe, near the Moselle home and the shooting range. And so I could be wrong. I was scribbling. So, of course, the defense wants to know, was this the same weapon used in Allendale? And they also want to know, why were they notified? Was the test bad? Or is somebody, this is crazy, is somebody using the weapon to murder other people? Because who knows? I don't know if this weapon is in custody, is not in custody, or if they only had the casings and the rounds. I am not sure. But holy moly, to find out that it's potentially involved in another case this far into it. They also talked about SLED tips, that they want to know all the tips that have come in the past or come in, and they wanted to know how they found the murder weapons. And the defense said that they don't feel that the state is taking the obligation seriously. So the state says, okay, look, of course we are. And this is the first time that this has been raised. And the state was, why are you raising this at this hearing? Why is this the first time that we're hearing about it? The state also said that Eddie Smith, that there is no cooperation agreement and that the defense has the witness list and the grand jury testimony, and that basically the case is just, Smith's case is just taking as long as it takes. And sometimes these cases take a long time. They just do, riding through the court system, years and years and years. It just depends on the defendant Depends on the issues in the case and depends on what's going on. We don't know. Is the defense right to raise that question? Yes. I feel if you got a co-defendant or you got a witness or somebody in a case and that case is pending, yes, the first question is, are they offering substantial assistance? Is there something going on? So the defense is saying, look, I just want to know what's going on. As far as they talked about Colucci, that was the case that got overturned, apparently. The state said that they were aware of their Giglio obligations, that there was an indictment without prejudice, which means when a case gets dismissed with prejudice, it cannot be brought again. But in this case, there was no prejudice. And the state said, it is in the process of being presented back. And that there shouldn't be any theorizing or whatever. He couldn't speak to whether a police officer forgot something. They're not sure that anything was misrepresented or whatever, and they're going to renew the indictment, right? They're going to proceed forward with the charges. So we need to figure out what happened in that case. And of course, I want to know because I wasn't involved in the first case. In the second case, they said the termination, they mentioned the name Ryan Kelly. I don't know whose names are what. They were talking really fast, talking about Charleston County. They said that they were aware of it and it had nothing to do with dishonesty or Giglio. And the state was, and I put it in quotes, we always renew, and they were referencing their obligation to look into things because this case was disposed of quite some years ago. They always renew any inquiries into personnel, evidence, witnesses, and all that stuff to see if anything new has come on. They also talked about tips. They said that they have provided all the tips before, and they are in the process of correlating and categorizing the tips. He said, I get emails from all over the world. And in reference to Allendale, he said, again, this is the first he's heard of it. He said that if something like this would happen, that a bullet match or a casing match or a gun match or anything, he said his first call would be to the defense and his second call would be to Your Honor, referring to the judge. He said, we actually have the commander from SLED in the audience today. They were talking about some Fitz article. I don't know who that is. I don't know if Fitz is a newspaper in the area or it's a podcaster or what. And he said he would be flabbergasted to find out if that was true. The defense said, look, these are just breaking stories. We were unaware of it. And the judge said, look, could you just forward that information to Mr. Waters? And the state was, look, Your Honor, we don't watch podcasts. We don't focus on speculation. And the defense was, when the state said regarding Colucci, the defense said, look, we still want the underlying docs. We feel that we're entitled to the underlying docs, which means whatever happened to overturn that case, whatever the police misconduct or allegations are, did the officer, was there an internal affairs or whatever was going on, the defense says, look, we want the whole thing. We just don't want to take your word for it. And I get it. And again, that's where I was surprised that they don't automatically get that. And the state said, of course, that they're going to take that Colucci trial back to the grand jury. So they are putting that out there. And then the judge was, look, defense, you can even go to the clerk. And the defense is, yes, Your Honor, we understand that, but we don't know if we have everything. That's true. The judge was kind of saying play fair. There's repositories for that. And I understand that the defense, they were talking about, we're just suspicious. And they continued to bring up in this case, based on the misconduct that had happened in the case with the clerk and the jury, they said, look, we have to do the best for our client. And we're not going to believe anything. We couldn't believe that this happened. We're suspicious. we can't believe anything, and we're not gonna believe anything, and I would love to take everybody's word for it, but we're just not gonna do that. And I kinda get that. Once bitten, twice shy. And then the defense was talking about the Kelly issue, that's the second issue, and they said, "Look, we just need the information. We want it." And so then this was interesting. The judge was talking about the law enforcement personnel because the defense was, "Look, we don't have any way to get this." And the judge says, "Look, if it's concerning our law enforcement officers, you send all that information to me, and then I'll read through it and I'll see if anything is applicable to the defense." And I was really surprised because if you're a public employee, right? We talk about sunshine laws and FOIA and public records. As a public employee, I don't know what's going on in South Carolina, but I don't understand why that's not public record. I mean, your personnel file should be your personnel file. Mine was, but the judge said, so I don't know what's going on in South Carolina. If y'all know, please put in the comments. But the judge says, no, if it's concerning law enforcement personnel, give it to me. I will take a look at it. And if there's anything that belongs to the defense or the defense should see, I'm going to give it to him. So on the law enforcement side, on the cop side, y'all got some great protections apparently in South Carolina to protect your data and your privacy and all that stuff. So thumbs up for law enforcement there. On the D side, we don't like that at all because you can't prepare any case. And where does impeachment come from? Bad behavior. There is usually, they talk about a pattern of life, victimology, and those types of things. Where there is smoke, there is usually fire. And there is a pattern. I'm working a case right now where the defendant didn't even know that the arresting officer got fired. The arresting officer in 2 cases didn't even know that the arresting officer got fired. But we were discussing what had been happening in the case. And I was, no, we need to look at those records because it's usually not an isolated incident. There's a pattern of behavior. And when I looked online, guess what? Judat. Dear Judat was fired. And there you go. And then going through the discovery, there's a pattern of issues. All right. So I think that it's not just work life, it's personal life too. Personal life too. Just a witness, just a regular witness. See, they talked about, I don't know, something about a federal case, some motion being moved and the federal court, I don't know what that is. They then talked about proposed, they were talking real fast down there, which I should be used to, but they talked about a proposed protective order. And this is very interesting. Pay attention here, y'all, because I'm going to say something, but then I'm going to come back to it later. So they were going over the proposed protective order and consent, and the defense talking about that they consented to it, and this was a protective order over certain information in the case that was ruled needed to be protected in the previous case. Now, the state says this is a new case, and since we have a new case, we have new filings. And so those filings need to be protected, and they need to be protected because they talk about maybe some type of investigative methods or personally identifying information or medical information or who knows what. So that those get protected. You can order records sealed, things like that. And the state says, because it was a long motion and the judge was like, I don't know what all this is, right? This judge has not heard the prior case. They moved it. And so the state was like, look, Your Honor, I'm sorry. I just attempted to provide history about why we needed these things sealed and how we want to move forward, how it started, how it progressed, and how things are now, what things remain sealed, what needed to be sealed, and all that. And the judge was like, okay, but you guys consent, you agree to all that. And both sides said yes, because they had worked it out. And so the judge says, I'm going to sign that. The next one they moved on. They were talking about here, and they were talking about voir dire is the jury questioning. And I thought this was very interesting. They were talking about in the last case, because of the volume of jurors and because of, especially, I would think, because people knew about the case, right? That's the first thing that you got to kind of weed out what are your prejudices, what are your biases, and what do you know about the case? Do you know something about the case that would make you unable to render a fair and impartial verdict? So in the last case, they said that they sent out a questionnaire and people mailed it out, filled it out, mailed it in to narrow down an immediate jury pool. And I thought that was a great idea because jury selection and bringing everybody to the courthouse and doing all that stuff can be very tedious and very time consuming, especially because you have all these questions that you have to ask even before you get to the nitty gritty, very important questions. And I thought this was pretty cool. So the defense and the prosecution last time sat down, came up with this questionnaire, basic questions. They mailed it all out. Then they weeded through the answers together and pre-agreed on a pool of people that could potentially move forward. And then they got more specific in the court voir dire, in the one-on-one questioning. And so they agreed that by November 1st, they would decide what these preliminary questions were going to be. I thought that was cool. The only question the defense said is, we have to decide what questions we're going to ask. And of course, at this point, this early stage, the judge said the trial was in April. And so the defense is saying, we're still not exactly sure what we're doing in this case. We're not exactly sure what questions we're going to ask. So we need to narrow down those questions and they need to be on the questionnaire. And the state says, yes, last time they agreed and they did it by the defense and the prosecution sat down, went through these mail-in responses. It took them 2 days and they decided. The defense also said that they want this process to be supervised by the judge, this voir dire. And the reason they said this jury selection, something, and it was back and forth, and I know that we had this clerk issue, but they were saying something about her daughter appeared, and I don't know what that was about exactly. The judge was talking about a new clerk. They were talking about the summons and the process, and it was interesting. The judge said that the jury pool list first gets generated in Columbia, South Carolina. And then that list comes down and the clerk excuses based on a screening process. And one of the things I kept hearing is 65 or older. And I thought, that's interesting. Would you, if you were 65 or older, want to be precluded from the jury? I'm not sure if I heard that wrong. Those of you that live in South Carolina, I was like, okay, those are the people that have time. I don't know. I thought that was interesting. And they were talking about that the big list comes down from Columbia. Then the clerk goes through a process and screens it out based on supposedly, I don't know, statutorily or agreed upon criteria. And the defense was like, well, this concerns me greatly. The defense was saying, I want to see that original list that comes down from Columbia. I don't care whether they've excluded it or not, but I want to see the original list. And I would think that they should be entitled to see that list. And remember, with problems with the clerk in the previous case, the judge just wants to make sure that the defense wants to make sure that everything happens fairly and that there's no bias. The state was talking about that the only eliminators are age and residency, and which again, I thought was interesting with the age. I guess everybody's incompetent after 65 and you can't make a decision. Or is that because of medical condition? I don't know what that is. Do y'all know what that is? That's crazy. And the state said also because of potential close relationships, and they talked about certain people that were eliminated in the first trial. The defense was talking about, look, I want the original list. And he says, quote, call me suspicious. And he talked about the clerk and he said, quote, so she could sell more books And he wanted to know that this bias and whatever that was going on, he wanted to know, quote, when did that start? And everybody was seeming to be surprised about what happened. And the defense said, quote, I never expected it to happen the first time, talking about, look, do you really expect this to happen? And he's like, I never expected it to happen the first time. Who knows? So what am I going to expect this next time? He talked about, and he said, quote, our Supreme Court found that she did, end quote, talking about the clerk, and once bitten, twice shy. And the judge was like, well, we're going to make sure that doesn't happen. And the state was like, look, we're not going to have shenanigans. And the defense said, look, we were not able to get the document the last time, and that the clerk was, quote, found to be a horrible liar, end quote. And he said, quote, call me naive, end quote. And he said basically that he wants it. The state said that they did get the dumps. So I don't know. The defense said that they want the judge to have the list and make sure that the process is good. And the state said, look, you know, these are the procedures that we put in place the last time. It worked well, and we definitely want a fair and impartial jury. And we want it. And last time it was even done under the supervision of the judge. And the defense was like, look, we just want the jurors that are in play. The next motion was very interesting. And again, I want to do more on these separate areas. If there's certain ones that you want to know about, let me know. They were talking about the state wanted to exclude the polygraph. And they said that it was a prophylactic motion. It was a pre-motion. They were preparing in advance, and that they had filed it in the first trial also. They were filing it here in the second trial. And they talked about the case law being clear in South Carolina that, quote, polygraphs are a no-no, end quote. They also talked about the US DOJ manual stating that polygraphs are, quote, not a lie detector, end quote, and that deception may not be related to concerns of guilt or innocence. And that they want to make sure that that the defense, quote, does not say the P word out loud, end quote. Talking about the judge giving an instruction that the polygraph word will not be mentioned. And then the defense said, generally, Mr. Waters is correct, but they brought up this case, State v. Eastwood, and that the Supreme Court said that there is not a, quote, absolute ban on lie detectors being used in the cases. They talked about the Eastwood case, and the defense brought up that Eddie Smith had a proffer, and a proffer is like a quid pro quo deal, right? A proffer agreement with the state, conditional on passing the polygraph. And when he was asked the question, did you kill Paul and Maggie? He failed it, quote. They then canceled the proffer. So the defense is saying the state then canceled the proffer. And they said, look, we can litigate this closer to trial, but Mr. Murdaugh passed the polygraph with, quote, flying colors with the same examiner. And they were saying, look, we're just giving this example, and the state relied on it. And they were shocked that they didn't call Eddie at the first trial. And the defense is like, look, Your Honor, we're not going to mention the polygraph word without your permission, right? It seems like the defense is going somewhere, and they might want to use it, maybe for impeachment or whatever. They don't know whether this Curtis Eddie Smith, is going to be called at the second trial. And then the state says, look, we never had to deal with Eddie Smith, and the polygraph is only an investigative tool. and we, quote, never base decisions on them, end quote. And he said the Eastwood case does not apply. They talked about State v. Counsel. That's a case, I don't know how to spell that, when deception was shown, and reiterating that the polygraph itself cannot show truth. All right. They're saying that it only shows that there's deception about something, something. That's what they're saying. Then the defense was saying, well, Your Honor, I think that's very interesting because we can't bring it up. If we think about this, this is not what they said. I mean, they're talking about it, but we need to think about where they're going here. They said Murdaugh passed with flying colors, but Eddie Smith didn't. And that the state used it to fulfill the proffer, to fulfill the plea agreement or the whatever was going on, whatever they offered in exchange for him passing the polygraph. And Eddie Smith apparently didn't pass the polygraph. And so he didn't get his deal. He didn't get his quid pro quo. And the state was relying on the successful passing of the polygraph. Think about this for a second. And they're not saying this, but we're inferring or we're speculating based on this. The state had just said, our client passed the polygraph. Eddie Smith didn't. But you're saying, so we may want to use it. But you're saying, no, you can't use it, but you used it with Eddie Smith. You can't have your cake and eat it too. You can't say it's unreliable in one area, but yet you relied on it, didn't you? The defense was saying, Your Honor, please don't issue a blanket order. And they went back and forth, and the judge said, the ruling is the results of a polygraph exam are not admissible as to the defendant's willingness or refusal to submit to a polygraph test. The judge said there should be no mention of a polygraph test to the jury. And she talked about counsel and Palmer. Should the defense seek to use the polygraph exam, they're going to have to, something related to a polygraph exam, they're going to have to seek a ruling outside the precedent of the jury or risk a mistrial. And then the defense was saying, Your Honor, I think you mean contempt, not a mistrial. The judge was like, just don't scream polygraph before talking to the jury. And the defense says, we may seek to do that in the context of testimony. We may need to do that. And the judge said, just let me know if we're going to go there. Then we got to the big one. And again, I can get specific. I'm going to go back to these motions and get specific. I'm just trying to give you the update. Then they talked about the use of the defendant's prior testimony. We had talked about that. And the judge was like, I've done a lot of research on this. And the state says, look, the defendant gave multiple statements to the police about not being down at the kennels, but yet multiple witnesses identified that it was his voice. Minutes before they died, they talked about Judge Newman and they want the prior testimony. Something about, quote, why did you lie? They referenced Harrison. This is the state referencing Harrison, which we talked about, that according to Harrison, it's admissible. At 804A1, it's admissible. And they referenced the specific language that we talked about in any other, that it is available per statute and under Harrison if it's in any other criminal case, or it is inadmissible in any other case. And the state says, look, Your Honor, this is the same case. And they said, there's no question here. But then the defense got up and said, look, hold on a second. Sorry, I'm trying to see my notes here. The state said, this is the same case. There is no question of it. We are starting from new regarding evidentiary stuff. They quoted Tucker. They said that Tucker is a little different, that the defense is arguing that the Supreme Court compelled or impelled over the financial records issue, which we had talked about. And they said that the defendant was very clear, I want to testify to explain the kennel video. They also said that the Supreme Court went into the 404 detail, admitting that motive evidence would be tailored. And the judge said, well, we may need to go along with what the financial crime did. And the state said that they would consider impeachment if the defense presents a new theory, right? They're trying to say, look, we need this testimony to get in, or that if they're going to change the facts, it would be fair game. And the defense was, look, no, this is not allowed, both under state statute and the Constitution. And they're saying, look, before we get into the constitutional issues, we're just going to get into the state issues here. And they said this 1911-50 prohibits it being used in another crime by definition. And this is where, remember earlier when I said, the defense said, look, at 10:23 a.m. this morning, Mr. Waters, the state said, quote, this is a new case for this motion. And I did pick up on that this morning. I was like, that's interesting, because I had done the video on the fact about the different case, that it could not be used in a different case, but it could be used in the same case. And he was talking about that this was utilized to protect the defendant. And they're talking about, the defense is talking about indictment control. They're talking about trial de novo, which is a new trial. They talk about irrevocable waiver. They talk about Tucker. They're saying Tucker's not the same. And they said that everything is new. New motions in limine, new motions. What did we talk about? To seal. And they talked about that let me stop here for a second. The question to ask here, and I'm going to argue this a little bit. I might go through it and go through that motion. But basically the question is here, what makes it a new trial? What makes it the same case versus a different case? Because the defense is saying, look, the state said, we have to go through all this. We have to make new pleadings and new this and new jury and new. It's a new case, Your Honor, and that the state said it's a new case. The defense is, the state said it. And they also talked about, so then the defense went over and said, look, we have filed a motion to dismiss the indictment. They quoted a case called Thrift, which I don't know what that is. They said that it meets the standard for dismissal of the indictment. And they don't want to have the court and the state and all that to waste the time of going back to the grand jury and creating a whole new indictment. But if it has to happen, it will. And if there's a new indictment, it makes it another case. Therefore, the testimony would not be allowed. Strategy. I don't know if I saw the motion to dismiss the indictment. They talked about witnesses being incompetent. They talked about colorable claims of misconduct. They talked about fabricated evidence and that only direct evidence linking the accused to the crime. They said that meets the standard of Thrift, which therefore would force a new indictment. Not only a new trial, but a new indictment, which would make it a different case. And they said that's under the statute. They then went to Harrison, which is, they're talking about the Constitution. They talked about him having to testify to address evidence. They talked about Simmons, which is another case I'm not familiar with. And they said in the Simmons case, in order to assert the Fourth Amendment right, unreasonable search and seizure, the defendant apparently had to testify. And it was possibly an evidentiary hearing or whatever. And so the defendant had to testify to certain facts. And apparently at that Fourth Amendment hearing, or the common understanding or ruling or precedent is that if you have to testify to preserve one right, it can't be used against you. It can't be used against you for another right, Fifth Amendment. Typically, in court cases, a lot of Fourth Amendment issues, a lot of constitutional amendments, constitutional issues get argued in the beginning. And you have to put on evidence, testimony, and things like that. Fifth Amendment comes later at the trial. In order to get to the trial and argue those evidentiary items or hearings, they got to say something. So then that can't be used against them. That's what they're saying. And they were talking about that it would have been different if the financial crimes would have been brought in or not brought in. They said they objected, that it was preserved on the record, and they said that the statute is the easier ruling for the judge. And then the state said, look, I just heard from the SLED general counsel, kind of interruption, that regarding the 300 blackout, that they put the casing in IBIS and there were no leads. And he said, I'm sorry, Your Honor, this is about the prior motion. And then the judge was kind of, look, I don't understand. There's a thing. Sometimes the judge says, sometimes it's a real novel idea to just pick up the phone. This conversation about the 300 blackout and all this stuff. Like, why can't you all just talk to each other? Instead, we have to do all this stuff in court. And then the defense said, look, Your Honor, I've never questioned Mr. Walters, but I can't help question the SLED labs because their interpretation of no match. And he said, my question is, quote, did they pull the shell casing? Did they compare 1-to-1? And what he's saying, and again, we can get more into detail in a separate video, but what happens in the case is they take photos, they do different things, they put it in the system, kind of like CODIS. The DNA gets in CODIS, the C hit, the fingerprint goes into APHIS, see if they get the hit. The casing goes into IBIS, and it sees if it matches it. A number of factors could preclude from it matching. What he's saying is, I don't have another one, but I could use, did they take the casing from one and compare it with the other, side by side, one by one? Murdaugh case, Allendale case. He doesn't care about what the computer says. He wants somebody to look at it. That's what the defense was saying. And he also talked about the fact that, look, he's not going to trust anything. He mentioned something about blood spatter, that they were misled for months. They were lied to with the grand jury. They were lied to by SLED. And he said, look, my new thing is, quote, trust but verify when dealing with police officers. And the state was talking about, look, I'm not going to get into whether it was two ships passing in the night. He talked about, he called it IBIN, which is not IBIN, it's IBIS or NIBIN. And he said, look, I can find out more. He said, but we were told no leads or hits. And the defense is, look, if they submitted it, what was the result? We just want to know. And the judge says, look, just ask him, tell him, do you have a report for that? All right. Then they went back to the prior motion that we were talking about. And the state says, look, the defense is just parsing my words, referring to the fact that he said it was a new case. Semantics matter. Again, just like in the polygraph. How does it work in one part? How is it a new case in one part of your presentation, but then it's not a new case in the other presentation? How are you relying on the polygraph in this part, but you're not relying on the polygraph in that part? I get it. That's a good catch. The state's, look, it's the same case. Talking about Tucker, brand new evidence. He said he's willing to rely on the judge's parameters when they get there. They're talking about, again, these financial crimes, if they're in play, they're not in play. They were talking about, the defense was talking about, again, Harrison, and The defense says, look, it's the state, per Harrison, it's the state's burden to say that what they did not impel his testimony. If you recall from the other video, the statutory and the constitutional thing is that and I want to make sure I get this right, I could be incorrect, but the two-pronged test is, or the two different tests are, it can't be used in another criminal case, or if it was impelled, if the testimony was impelled, it can't be used. The defense is arguing Harrison, saying that because the state introduced the financial crimes, the defendant was impelled to defend himself and testify. He had no other choice. Impelled. I don't know what the difference between compelled and impelled is, like I said, but in the judge's look, it's pretty clear. All right, it is admissible based under the 1911-50. He said, look, the test is our Supreme Court 804B1, and she doesn't find the defendant's argument compelling. They talked about Harrison, that they don't know what the state's going to introduce. They don't know what's going to be allowed in or not. It is subject to the rules of evidence. It's not coming in if it's not relevant. And the judge said, quote, when you testify in a case, there's consequences, end quote. I highlighted here that she's going to evaluate it based on, she said, subject to what is being testified to. And then the defense said, look, we want to get it on the record. We renew our objection. And the judge says, you're welcome to revisit at trial. That was that. The judge says it's coming in subject to, we'll see how it goes, but she's going to let it in. Then they talked about this phone. They talked about the defendant's phone and the defense, having the defense turn the phone over. And the state talked about at the night of the murders that there was reference to the phone not being immediately seized or downloaded. They said on June 10th, it was downloaded. And and they did advanced download. After August, it was seized again. They talked about the fact that the defendant is a lawyer and that prior to the Attorney General's order, they only received redacted information and that the defense got all of it. They also talked about they don't want to violate any type of waivers, that absent any fraud, they're talking about the tank team. They want to give the defense a chance to review. And the defense says that they don't object to the motion process. The state said that with regard to the extraction, that it was logical versus a full phone, and that it only represents a snapshot in time, that data on the phone can change due to manipulation. They filed a motion to ask for it. They said a better solution under Rule 5 would be that they have to disclose it if they want to use it. They talked about it being a 256 gig file. And the judge brought up a good point. Look, the defense doesn't have to give you anything that they don't intend to use. And it's interesting because I've got that going on in a current case. I will save that specifically about a cell phone. But the judge said here that there seems to be confusion a lot about just because somebody has something, is it discoverable if they don't intend to use it? The state says, we talked about the Fifth Amendment. We talked about work product. They wouldn't access anything without their consent. They talked about the privilege. And they talked about the fact that if the defense, right now the defense has the whole extraction. And they talked about this is what the state wants it. But the defense is saying, look, the judge is saying, look, the defense hasn't said that they're going to use it. And so you don't get it if they're not going to use it. And the judge said, look, the only thing that I'm going to ask about is you can't wait until the last moment, because going through 256 gigabytes of data takes a long time. It does. You get a lot when you get that dump. And they talked about only for the phone. So the judge said, if you're going to use that phone dump or information from that phone dump, you have to disclose it to the defense prior to March 1st. And the trial is going to be, I believe, April 1st or in April. Trial is April 5th. And they agreed to that. Then we got to this DNA, and that is where I got a little crazy. And I know this is a long video, so I'm going to keep it succinct. And I'm going to go through this in depth because it's very important. I am very teed off that our police work is being handed out to non-police people. And I understand both sides of this issue. But briefly, there in this case appears to be, from what I understand it, and I did go through that motion. I'm going to go through this again. I'm going to go through this DNA in detail because of it. I'm just giving you the synopsis now about why I'm so teed. Apparently, in the first case, there was results from fingernail clippings that they did an STR result from some of the clippings. They had two samples. The first sample, they quantified it and they did STR testing. They got a profile, which they said was 99% Maggie and 1% unknown male. And they have extract left. They also had other clippings that they have not done anything with. It could be from under another fingernail. Sorry, something going on here. We don't know, just DNA. And I'm going to be succinct here. They have extract left from the original STR testing, this 99% and 1% male contributor. And that is what the defense wants tested. They said they have 3 alleles. I'm not sure. It was very confusing. Again, we don't have all the details on that. What they were arguing about back and forth, and I'm going to go into more detail, was that the defense wants Othram to take the extract and perform other testing on it to try to get more DNA from the extract, whatever's left, whatever they're going to do, something SNP, or excuse me, STR, which is CODIS, SNP, which is FGG, what I do. Plus, the defense wants this unquantified raw DNA, which has not been STR tested, not SNP tested, not nothing. They don't even know what they have. They don't know how many contributors, what it is, how much they have, anything. The defense wants it to go to Othram. And they went back and forth on this about who's accredited, DOJ policy, and all this stuff. And I'm going to get into it, so I'm not going to get into it, but I'm really teed off here. The judge ruled that Othram can have the entire untested sample. They even had the person from the SLED lab, the quality control person from the SLED lab, talking about accreditation and how the process should run. And they have handed law enforcement evidence, untested law enforcement evidence, which the lady said was to have it STR tested. And that stuff sounded like, according to her, because I don't know that policy, would violate the DOJ's guidelines about accreditation and quality control and that sort of stuff. And the judge said, send it to Othram. And they talked about that Othram was not accredited in STR. And if you remember, we've been doing it a long time. That is a very competent law enforcement function, has been used in court all the time. And now they are outsourcing police function again to, I don't care who it is, private labs, which I 100% don't agree with. I'm not talking about the defense position, about who should be tested, what should be tested, whatever. We haven't got into qualifications. We haven't got into transparency. We haven't got into lead versus tips. We haven't got into proprietary. We haven't got into contract eligibility. The judge, bless her heart, doesn't appear to understand this, may not know about what's happened in the other cases, and I am ticked off. And I'm going to talk about it. I said, you better just start exporting all the SWAT response, all the K9 response, all the uniform officer response. Why don't you just hand the entire police function to civilians? Just let it go. Just let it go. I'm 100% against it, and I will explain why more in that video. But I'm so teed off. They took a break, and I couldn't stop the hearing. I'm going to have definitely a DNA. I'm going to talk about it, the STR, quantification, all the stuff that they were talking about. I'm going to talk about that and why I believe in it and what's going on and how this is going to affect the judge has just set precedent. I'm really upset. Anyway, that's it. That's the overview. I will come back as soon as I can. If you have questions, put the questions below. But the judges gave the whole enchilada to a non-law enforcement company, private company that's been doing this stuff. I mean, I'm going to stop there. So that's it. Thank you for being here. I'm going to do the videos. Let me know if there's a particular one that you want to hear more of. I'm going to calm down. Plus, I'm having some work done here on the house. That's why, if you saw, I was going to go over the Carmelo Anthony, but I got some service people coming in here unexpectedly. And so that's gonna take up that, but I will be back maybe this weekend, depends on what I'm gonna do. But let me know which one of those, if you want to hear all of them, which questions you have and what you want to talk about, and I will see you in the next one. Thank you for being here, and thank you for, as always, supporting the channel.